See how that goes. My name is Amy Vandenbroek. I'm the Executive Director of National POLST, and I'm very excited to have Sandy and Vicki presenting on making POLST work when legislation is less than ideal. I think this is a question and topic that has come up in multiple states, and so having them share all the great work that they're doing in Arizona is, I'm just excited to have that happen. I wanted to thank the John A. Hartford Foundation for their support of National POLST and helping make webinars like these possible. Please stay on mute unless you have a question. The speakers have said that they want this to be interactive, so you can unmute if you want to ask the question, or you can type the question into the chat box, and either I'll respond or I'll ask the question. So if I see that you're not on mute and I see that you're making noise, I will mute you. So I apologize about that in advance. Otherwise, I'm going to turn this over to Sandy and Vicki to get us started. So thank you.
Wonderful, Amy. Thank you so much for the opportunity to share our story in Arizona. And we'll take you through some of the twists and the turns that, that we have learned how to adapt to. And it has certainly been a challenge. I'm not from Arizona, but lived there about 15 years. And very interesting enough, POLST in Arizona started with a grassroots effort by local clinicians in 2005. And they spent many years, I think, looking at what was happening in the rest of the nation with POLST and Oregon and California and some of the other states and Washington and New York, and really kind of like a kid wanting to bring those types of resources to Arizona. And I was not involved with that process at all until 2015, when our board of the Arizona Hospital Healthcare Association pretty much required me to start a end-of-life coalition collaborative type of work. It was kind of a mandate of a huge need that we're seeing way too many people in the ICU on beds that shouldn't be there, inappropriate ED visits, high denials. We really need to do something to stop that. So when I started, and I have worked in hospice and palliative care, I'm a nurse by background, decided that, boy, we really need to look at what's happening in Arizona. So, you know, our board meeting was right at the end of 2014. And so in 2015, I actually was like, I think maybe November of 2014, I reached out to a couple of folks and asked about, could I join your POLST group? And was told absolutely yes. It's just volunteers who want to get together. It was being led by a nurse practitioner, palliative care nurse practitioner in one of the large health systems, and volunteers who came from payer groups to hospices, home health agencies, EMS, attorneys. And so I attended one of the meetings and was really excited about it. They had already developed and gotten approved, worked with Amy and the National POLST and gotten developed the POLST form. They were developing a strategy. They kind of had the checklist of everything that we should be doing to develop a strong infrastructure of a program. And we're kind of working on that as we could. You know, we were trying to figure out, okay, how are we going to implement this? And we started going out and really educating, and I should say it's really, they had done this before I joined. They'd met with the medical association, Geriatric Society, and different organizations, and EMS, and talked with them about, we have this POLST form, we're going to be beginning implementing it across the board. And one of the small health systems, Northern Arizona Healthcare in Flagstaff, one of the palliative care docs had wanted to pilot the form, and she could do it in both, there was two, it's a 2 hospital system, fairly small. And so that's kind of where this was when, really trying to create an infrastructure. And then we never saw the legislation coming. It hit us totally out of left field. And I work for the Arizona Hospital and Healthcare Association, and we have a lobbyist. And so what happened is the lobbyist actually contacted me. She sent me a text that she was on the floor on February 18th of the Senate, and the Centers for Arizona Policy put this bill forward. And she wanted to know what I knew about it. It was anti-POLST legislation. And I said, I don't know anything about it. Tell me everything you know. And of course, if you know the way the Senate works and everything, or the bills pass, it's very fast moving, And so when she got back to the office, we brainstormed, and I reached out to the lead of POLST at that time, and she didn't know anything about it, but she worked for a large health system, and she reached out to her lobbyist, and I got all those emails and everything and this history. And so the group that supported this, that ran the bill, is the Center to Advance Policy. And they're a nonprofit advocacy group who really care very deeply about defending the foundational values of marriage, of life, of family, and religious freedom. They're very strong pro-lifers, and they're very, very powerful in the state of Arizona. They tend to, right now and historically, we've pretty much had the Senate and the House controlled by very conservative Republicans. That's still kind of the way it is today, even though we do have 2 Democratic senators, and so little things did get mixed up this year. But it passed fairly quickly on the 18th, and I said, what can we do to stop this? We have to stop this. Let's all get together. Let's stop this. We need to get people to testify against it. Well, our medical association testified for it. And I kept thinking, what is wrong? And it moved very, very quickly. We kept putting together documents to get in front of people. But again, I was not the lead for POLST at that time. I was just one task force committee member. But it was like a freight train moving very quickly, and we could not find anyone that would support or stand against it. And I say that because of political capital. This group is so strong that no one would want to use their political capital up to go against them. To quote one of the senators that has always been friendly and supported healthcare initiatives, it would end her career. And so they weren't willing to die on this, and said, what else can we do? So this is the statute as it ran through these different committees. It ended up getting adapted a little bit, but Healthcare Directive Conflicts A was already in, has been in statute, but B is the new one. So notwithstanding any other law, there's a conflict between a provision of a healthcare directive, the decision of a patient's agent pursuant to a valid healthcare power of attorney, or the decision of a surrogate decision maker pursuant to this section, a healthcare provider's order, including an order regarding life-sustaining treatment or a similar document, the healthcare directive, the decision of the patient agent, or the decision of the surrogate is presumed to represent the decision of the patient. That's not always clear, but I can tell you when I read that the first time, I thought, POLST is dead. If the previous documents are actually going to trump a POLST form, we're dead. There's nothing that we can do in the state of Arizona. We have to get this legislation changed. And very interesting enough, this is the information that was actually in the Centers for Arizona Policy white paper. It was all wrong or misinformation. And I actually, and if anyone wants this information, we have links to these three committee hearings, and I've watched them repeatedly. So, you know, I know who actually these people are who said this information. And it's always amazing to me how little legislators do their own research, how they believe whatever is being said to them, even though it is not true. So, you know, they really felt strongly that the patient's preparations, their previous documents have to take precedence over a doctor's preference. And that families take the time to prepare to talk about this in complete documents. And those previous documents should not be disregarded if a POLST conflicts with clearly documented healthcare directives. So they totally negated the fact that wishes change as health declines, and that if the documents aren't updated, that a person can actually change their mind. Another point was that the law should safeguard the patient's wishes to the utmost, and that stakeholders came together to actually develop these advanced directive laws, and we need to actually protect those, and that POLST opens the door to untold abuse, and that patients will suffer the consequences, and that POLST puts patients in harm's way, and it's part of a larger movement of managed death or euthanasia. And these are attorneys and physicians actually stating these facts on to the Senate and the House. And so the POLST form is troubling. We must take action to stop this movement. And then comments from legislators that were in the different committees was just an aha to me of how little knowledge that our legislative leaders have on end of life and healthcare and POLST. That a POLST will conflict with the living will, that they're filled out by physicians, and that patients don't even have to consent or approve anything, that it's really the death panels. And that the current law, again, was that stakeholder process, and that we don't want to disrupt the process, meaning they truly felt everything was currently working very well. So no testimony other than one doc that was really questioned the process, that POLST actually circumvents the law, that the patients and their families know best, not the doctor. And then the bill protects patients and families from doctors. So you can see the vein of a tremendous amount of distrust of physicians. And you just have to wonder why. But remember, this was 2015. This was when Sarah Palin, when the death panels and the insurance companies are trying to keep healthcare costs down. So another comment was, physicians are going to make decisions without any input from the patient. A senator actually said, we need to ensure that patient rights are honored, totally not understanding what POLST was about. And then the testimony by the young attorney by the Center for Advanced Policy said that in many states, POLST was only signed by a physician and not by the patient. One Senator Kelly Ward, who's an ER physician, actually said it was offensive that physicians can override patients' wishes, and that patients' wishes patients should be making their own decisions. This was an ER doc. So it was very surprising, I think, for us as we took a look back on what actually happened, because we were so surprised. We thought this is a wonderful opportunity for us to get out there and educate, because we were having this swirling of facts, and we were trying to get a trusted source to actually go before committee and testify, and a legislative champion. And what we actually found by watching the Senate committee is that this bill had actually been proposed in 2014 and been voted down and came back in 2015. The POLST task force had no knowledge of that, absolutely none. But we were not able to muster legislators to support opposing the bill. We were not even able to identify a physician. We even thought of, and of course we had no money. We were just a group of volunteers. So we knew that we had to figure out an alternative approach. And because it was dead, bottom line, no one was willing to work with us to rebut and go against the Centers for Arizona for Advanced Policy. So,
Sandy, this is Amy. I had a quick question. You said that the task force didn't know that this legislation had been introduced in 2014, and then it came as a surprise to you in 2015. And looking back, was there anything the task force that you would recommend states do so that they either can learn about this or be more aware when something comes up? Like, is there even like a Google search or something?
Thank you. I think that is extremely important. You must have situational awareness of who is supporting you and who is against you. And I think the task force, and I'm not critical of them because I was, even though I was fairly new as a member, we had talked about CAP, and we had talked about the Catholic diocese in the Phoenix area being not supportive of, but we had no situational awareness of legislation. And I do think it is extremely important for states to know, to do searches on what is the legislative history of advanced care planning, anything having to do with advanced care planning in your state. Know your laws, know what's been on the books, talk to lobbyists, talk to your legislators. I think that's really important, that state POLST leaders need to actually take the time to do that. And I know that not all organizations have a strong infrastructure. This is where I was abhorred as a nurse, and as at the time I was a vice president with the Hospital Association. I was angry. I was angry that this could happen, that there could be such misinformation out there, that our legislators don't do their homework, and that lawyers and doctors would stand up and say mistruths. And I had a tremendous distrust of the process of legislators, and I was angry even with my organization, because I worked for a lobbying group, that had policy and advocacy, and I couldn't even talk them into standing up and being supportive of POLST. And it was truly a come to Jesus. And that is when I got my organization to say that, we need change in Arizona. And if you want us to start work to improve end of life care for the people of Arizona, then we have to be bold. And so we have to stand up. And so this is where I talked with the current lead and said, would you allow the Arizona Hospital Healthcare Association, myself, to be the lead for Arizona POLST, because we think we can provide the infrastructure the website and, actually develop a strategic plan and work the plan a little bit more robustly than the volunteers were doing, to actually have minutes and to have that in place. And I think, being very respectful of all of the work that was done from 2005 to the end of 2015, because they did a tremendous amount of work, and it was really good work. But to develop programs in states like Arizona, that's the Old West, the Cowboys, and knowing our legislators, we really needed to beef up our process and our programs. So in 2016, the handoff was early in 2016 to our organization, but we kept the same task force. We just provided a little more structure because, again, all of this work is pretty much volunteers, and it was totally unfunded. I mean, no funds to support this work. But the first thing we did was we had legal counsel review of the statute. And it was very, very interesting because in the legal opinions said, in theory, these conflicts should not arise very often. To the extent a patient's wishes regarding treatment are known, then surrogates and providers should be working together to ensure that they're carried out. So that this would only come up once in a great while, this conflict. But then they went through 2 pages of details of when it could happen, when, that type of thing. But most of the time, if they have a valid healthcare directive, and the providers follow that directive. And that doesn't change. Most of the time, providers have conversations with the seriously ill and their families. And so most of the time, there's not going to be this conflict. But there are some times, especially if there's no documentation and then you've got a surrogate. So in Arizona, we've got an agent. If it's a healthcare power of attorney, it's called an agent. And if they have not identified a decision maker, it's called that surrogate. That's in the terminology we use. So we thought the biggest risk is going to be if there wasn't any documentation. And the surrogate would say one thing, and it really wasn't following what the patient had said to other family members or to their physician, or it was unrealistic. So we really felt very strongly that that this was, we couldn't figure out a way around it, actually. Even though they said it was unconstitutional, and why did they say it's unconstitutional? They virtually said it was unconstitutional because as it applies to the situation involving the agent or the surrogate making a decision that derogates the patient's actual expressed wishes as documented on the POLST form, it's arguably inapplicable to the decision made by the surrogate, because it's in conflict with other Arizona statutes that we're going to follow a patient's wishes. So in the case of an apparently valid and unrevoked healthcare directive, the healthcare directive must take precedence. Well, that it pretty much violates the patient's rights. So a surrogate's going to take precedence over a patient's rights? No, we give that power to the agent or the surrogate, one way or the other. So, saying that it's unconstitutional and wouldn't hold up in court, yeah, but who's going to take it to court? We never want to test this. So we felt at that time our options were to revise legislation. Let's go for that one. Let's take it. Let's revise that legislation, or figure out how to make it work. And so we spent a good year and a year and a half really working on how could we revise the legislation to get around the Centers for Advanced Policy. What could we do to get around CAP? And then we decided to go meet with CAP. So our CEO, who was attorney, went and met with them, invited them actually to meet with me, to look at our education, to look for POLST, and bottom line, they didn't want to be educated. They didn't want to work with us. They want this. They want everything done all the time to support human life. And so we drafted new language. We met with someone who always sponsors our bills and told us again, this would be my political death. I cannot run your POLST legislation, even though I really, really, really want to. We could not find anyone to sponsor it. And Sandy went home on that day very sad, very sad. My face was very, I went into my office, shut my door, and burst out in tears. Because I mean, it's like, we really, really need to do this. The good news is she said she'd sponsor our advanced directive registry bill, which she did, and it passed. So it's like small wins. So we knew legislation wasn't going to work, and so then we had to figure out a way to make this work. And you put your thinking cap on. You don't sleep at night. You talk with your task force. You talk with everyone you know. You talk with legislators. Talk with Amy. Talk with partners from different states. How can we possibly make this work? How can we find a way around this? It looks like I do have a question in the chat. Interested organizations can and must follow all legislation introduced each session, specifically so that they know of and can act on bills that are introduced. This would be part of the responsibility of an organization's lobbyists. Hard to do with volunteers, requires resources. Yes, I definitely agree, Charles. And we learned that the hard way. And it is very hard to do with volunteers. And that was one of the reasons why it made sense for our hospital association, because we do have a lobbyist and they do track every bill, and anything having to do with healthcare comes before us. And so that's thank you for that. I think it is very important. And most of POLST leaders are wonderful. It's wonderful if you have grants and have large paid staff, but not always. And so then I'm going to turn this over to Vicki Buchda. Vicki, do you want to take this? And
sure. So Sandy teed up for us that we had to figure out a way around this, and our way around is through education. And so what you're seeing in front of you here is a slide that, for those of you who are from Arizona or have sat through our POLST sessions, this will look very familiar to you because this is directly from our slide deck, Educating in Arizona. So basically, what we outline in this slide is that if there is a conflict between the healthcare directive and the POLST form, the healthcare directive is presumed to represent the patient's wishes. And so to reduce the likelihood of that happening, we encourage all documents to be updated at the same time and attached together. That attaching together is just that extra level of insurance. We also encourage conversations to ensure that the patient surrogate knows the patient's treatment goals and wishes. Now, that second bullet point on this slide, while it fits perfectly with our whole strategy in the state of Arizona and is one that we have heavily relied on, it is right out of the National POLST documents. So clearly we are in alignment with where we are as a nation as well. Next slide. So what we teach at we are completing a POLST that we follow a number of steps for consistency, just to make sure that everything is in alignment. So best practices include updating the healthcare directive at the same time the POLST form is completed or revised. And especially if it's revised, the last thing you want to do is have an outdated advanced directive and then a more recently dated POLST form, because if they're in conflict, that could be an issue. We also know that when a POLST form is attached to the patient's living will, it has the same liability protection as a living will. So that was really important for us, and a talking point that we use often when we meet with physicians, practitioners, and PAs who will be not only completing these forms, but potentially providing care based on these forms. So as long as we make sure that things are bundled together, there will be those protections for those providers. So again, attach all the forms together. And then another best practice that we learned is that if we added a statement to the living will that the POLST form is attached, that will also provide an extra level of protection. So we'll show you here in a second an example of our Arizona, what we refer to as our Arizona short form, but we actually have an Arizona living will that is 2 pages front and back, that includes the advanced directive, the medical power of attorney, as well as the mental health care power of attorney, which is something that is separate in the state of Arizona, but it is on just 1 page front and back. And we'll show you what that looks like. In terms of the living will, again, if a healthcare provider makes a good faith healthcare decision based on the provisions of an apparently genuine living will, that person is immune from criminal and civil liability for those decisions. So by attaching those forms together, it again provides that level of protection for them. And of course, the other step in this whole process is to always verify and review the patient's treatment wishes with the patient, with their agent or surrogate, and the loved ones, who as far as wide as this can be shared, as far as the patient being comfortable, that's really what we want to do. So with that, Sandy, okay, thank you. Now we know there are some risks, and it's important to understand the risks. So we do talk about this in the class, and we also talk about it with patients and families when we're talking with them, because oftentimes we get queried about POLST in the state of Arizona from the citizens in Arizona. And so we always include in our education that a failure to update the living will at the same time as the POLST could result in risk to the patient and provider. The risk to the patient is that the POLST form might not be honored if there's a conflict. And of course, we're back to Arizona law requires the healthcare directive or surrogate to trump the POLST if there is a conflict. So again, really making sure we resolve those conflicts. And the bottom line is the patient may not receive the care they want. And honestly, we get a lot of questions from the citizens in our state, and they'll call Sandy and I, and they'll say, can you guarantee that my wishes will be honored, that what I have documented on this POLST? And we would love to be able to guarantee. Can't always do that, but by at least having it written down and telling them and encouraging them all their documents and have the conversations, it increases that likelihood dramatically. And then the increased providability and exposure. So again, if there is that conflict between the POLST and the living will, or the surrogate decision maker, and the POLST is followed, that is definitely one of the risks. So we want to make sure that people understand that as well.
And Vicki, I want to stop you there just for a second, because this is reality, and we get these calls all the time from ERs or social workers or a physician where they've got either a POLST form or a living will document, and this is what the patient wants, and the family wants to trump that. And what we really always try to talk about is this is what the care that patient wanted.
Yeah.
And I've actually had one situation where the patient, said, "I'm right here, talk to me. Don't talk, doctor, don't talk to my loved one. I still can make my own decisions. I might be having a heart attack, or I might be, but talk to me." And, I think that that's something we always try to stress with when we're doing our professional education to physicians and nurses and social workers and PAs and nurse practitioners, is that if you want the patient to receive the care they want, which is what POLST is all about, then make sure that there is clear communication with that person, because that's conflicts arise so many times, and facilitating that conversations with the loved ones. This is the prime time to do that, is when you're having that goals of care conversation and completing the POLST form to make sure everyone's on the right page.
Yep. So some of the nuts and bolts of Arizona POLST, first of all, it's imperative that we understand the Arizona conflict law. And again, we've touched on this a number of times, but our interpretation is that the advance directive takes precedence only if there is a conflict. So if everything's in alignment, the POLST should be followed. And our solution to the problem with the conflict law is to mitigate that chance of conflict. So whenever possible, we encourage that all documents are updated at the same time and attached together. And then we developed consensus around the standard of practice. And so when people pose the question to us, are you working on legislation? We're now comfortable actually answering the question saying, we don't need legislation in the state of Arizona because we operate under a standard of practice. And we developed the standard of practice in conjunction with other key stakeholders. So it wasn't Sandy or the hospital association moving forward saying this is what would happen, but we worked with our medical and osteopathic associations. We worked with our specialty societies. We worked with other disciplines, nursing, home health, hospice, family law. We're working with the paramedics and the first responders who are out there in the communities and are oftentimes the first ones to respond when there is a call. And so we worked very, very hard to get everybody on the same page. This was not easy. It looks simple on a slide to say we developed consensus. This took time and many, many conversations. And even, for example, within the EMS community, some were convinced, some weren't. We started out by doing a pilot in a smaller town in Arizona and got some traction and some experience with that. And that really helped us in terms of then being able to have people from one discipline talk to others within their own discipline to help them see that this could work. Next slide, Sandy. Thank you. So this is an example of the Arizona Living Will that I talked about. This is that two-page document. And what we did here, as you can see, the part that's circled is that there is a spot where the patient can initial that. It says, I do not want life support treatments. I want to focus on being comfortable and I want to have a natural death. And then in a little bit smaller print there, it says this to you because I know it is small. Attached are the additional directions to this living will. Please check. And so there is a box to check for a do not resuscitate or pre-hospital medical care directive. This is something we have, actually, we do have legislated in the state of Arizona, pre-hospital care directive that EMS will follow. So it's printed on orange paper. If it is easily accessible when EMS arrives, when they call in for directions, they will let the base hospital know that there is a pre-hospital care directive and they can honor that. In addition, to the right there, we have a box for POLST. so that we can acknowledge that POLST is an additional direction, that set of directives that needs to be followed. And then there is a spot there for people to write in if they have additional statements or desires. This again is the whole idea, is to make it easy so that at a glance, especially if it's a circumstance where there is, you know, time is of the essence and it might be a first responder sort of a situation, that at a glance we can see what the patient wants. We've got the forms all together, and when they're calling in for direction, then they can represent accurately what the patient indicates they want.
And the reason why we did create a one-page short form living will and a one-page healthcare power of attorney with mental health authority was simply because we knew it was going to take too long to do the 28-page Attorney General document. And it was a barrier, and we had to come up with a way to overcome that barrier. We had to make it easy for them. And this was a way of trying to make it very easy for them.
I would add, though, we did work with the Attorney General's office, and their 28-page form is very thorough, as you can imagine. There's Q&As built in, and it addresses absolutely every circumstance. And while we didn't want to do something that was contrary to what the Attorney General had done, we shortened it up, but then we worked with, and they now have similar language in their forms, and they have a checkbox as well for POLST. So we saw that as a really big win, because initially they were not convinced that that's something they should adopt, but that happened with the last revision to that 28-page form. So these are the kinds of FAQs, frequently asked questions, that we get in the state of Arizona. So I'm going to pose some of them, because we know that some of you on the call have also had these similar questions. And so we'll just kind of go back and forth and address these right now. And then we have a couple other remarks, and we'll take your questions as well. It looks like we might have some things going on in the chat here. So let's just go through these. What does standard of practice mean? Sandy, I'm going to pump that one to you.
So as we were meeting with the medical associations, the Osteopathic and the Arizona Medical Association, we really had a very robust dialogue of what does standard of practice mean. And our discussion, bottom line, if you look up the definition and by AMA, it's standards that are based on credible scientific evidence published in peer-reviewed medical literature. But we took it down to a different level. And so my question to them is, if a physician is caring for someone who's seriously ill, is it not the standard of practice that they would have a conversation with them about their illness, to make sure that they have an understanding, so that they understand their prognosis, and that they discuss treatment choices and they write medical orders that align with the patient's goals of care? And without a doubt, there was 100% consensus. Absolutely, that is the standard of practice. And they felt very strongly, and it wasn't just one conversation. They went to committee to committee to committee, and then to their boards. And they all, every group actually ended up being fully supportive of those kinds of statements, that it is the expectation, it is the standard, that if we are caring for people who are seriously ill or frail, and we would not be surprised if they died in the next 1 to 2 years, that we should have conversations with them about their goals of care and write appropriate orders that align with those goals of care. There was no doubt. It passed unanimously. The difficult part in all of this is that there was a group that tried to get medical aid in dying through at the same time with the Medical Association Osteopathic, and as we were trying to do POLST. And they, what was the difficult part is they would not approve medical aid in dying, but they did approve POLST. Both of them did, and across the board. I think I answered that.
I do too, and I think you touched on how the decision was, who made the decision and how. Do you want to talk about the POLST task force and the work of pulling all of this together?
Certainly. This was a large undertaking of, it wasn't just a small group saying, okay, this is going to be the standard of practice. We really vetted it with many, many different communities, as Vicki talked about with EMS, and we had them change their algorithms in the back, so it does, that the EMS will honor POLST, and then did lots of education across the board with, family laws. We worked with the nursing homes and assisted living facilities and home health and hospice. We got input from people in the community. And so we really felt strongly that there was consensus across the board that, and there was not this opposition that these groups had thought there were. Once we did the discussion in the education, and it's ongoing because people are new and people come into the state all the time and don't understand, but it was really a large undertaking by many people on the task force that did this work.
And then we also touched on this one a little bit too, but how do we educate providers on POLST being the standard of practice?
We hold monthly intro to POLST webinars. One of our faculty is on or was on. Lori probably had to drop off. Lori Weber is one of our faculty. We have many faculty. Most of them are volunteers. We have a small grant that we do try to pay people. But we also, we have a website, Arizona POLST.org, and we answer the phone. We answer emails. We're always available, and we do a lot of speaking engagements on POLST. Vicki spoke at Leading Age. We speak at Home Health and Hospice. Different annual meetings. Just across the board. And it's not, when I say we, it's not necessarily Vicki or I. These members of our task force or people in the community. Actually, we provide our presentations, we share them pretty shamelessly, and they take them. But we always want to make sure that they're interpreting it correctly. So we try to listen in or be present when they're presenting, or review their final presentations. I know it's POLST was presented at the local PA society, physician's assistants. It's been at nurse practitioners, the physicians at different meetings, the geriatric society. So it's really across the board. We try to work with family law and different conferences that they have also. We've even presented on POLST to the state risk management group. Which are across the continuum of care, from payers to large health systems to small folks. So we try to be very thoughtful and reach out.
Are there issues that you are aware of at this point that you'd want to point out to others, or lessons learned? I know we do have one more slide where we have a couple of those listed, but are there things that come to top of mind before we talk about those?
I think it's the question that you brought up. Patients want a guarantee. And that is their biggest thing. They truly want that guarantee. And it's, we do our best to reach out to people. But the biggest thing, and, I just think there's still a lot of people that have never heard of POLST, even physicians. But through our monthly intro to POLST workshops, we've also got longer workshops that are train the trainer so people can get the information and use it and train it within their organizations. And we actually offer CMEs and CEs and for nurses, physicians, long-term care administrators, and social workers. So by offering the free CEs for these workshops, then that incentivizes it a little bit. But I think the issue is I just think it would be easier if it was legislated and they didn't have to worry about all this. And then we always bring them back to, but this is a best practice. Actually, wouldn't it be better, that you don't just talk to the patient and complete a POLST form, that you actually talk to the family and everyone is on the same page and all your documents are together. And now that we're we almost have our registry ready to go here in the next 6 months, it'll be live in Arizona. For us to be able to have all of those documents together in one place that EMS or any other healthcare provider could access. So we try to address those issues. There's a few one-on-ones where there's questions or families disagree, but we're usually able to talk through those together.
Well, thank you for that, Sandy. And we'll go on to the next slide, and then we have about 8 minutes left for questions. So the other thing we want to talk about real quick is that while, in looking back, it might sound like, we identified a lot of things, we busted our way through them and everything is great. There really are barriers that we have to be cognizant of and very, just very mindful of. And one is that it does take more time for providers to include that healthcare power of attorney and the family and loved ones in the conversations and to complete all of the advanced care planning documents. We see so many times that, they're willing to start the conversation, but then they're turning it over to somebody else, which actually is great if they are capable of following through and really doing that. But making sure that that all the documents are done is just so extremely important. We've set that expectation. We developed the short form. We added the checkbox, trying to make it as easy as possible. And then I believe we mentioned this earlier, but we do have a contract with Prepare for Your Care, and we developed the Arizona large print form, which also has a checkbox for the attached POLST. So again, it's anticipating those kinds of barriers and then just trying to do whatever we can to make these things easy. And I think Sandy's last comment about, if we just legislated it, wouldn't it be easier? Might on the surface seem easier for some people, clearly not so easy if you ever need to change that legislation. And in terms of sharing with other states, everybody has to be aware of their own current reality. And ours is that legislation would not be, wouldn't necessarily be in our best interest to do. And we believe we've found a very effective way around it. And again, education is the way to go. So we do those monthly webinars on the introduction to POLST. It's a 1-hour webinar. We do offer CME, CE, social work, educational units, as well as for nursing home administrators, really trying to attract a wide audience so that we can get the word out there. We do get lots and lots of questions from a variety of providers, including emergency department personnel, and honestly, even hospice workers and others. We're always needing to provide clarification, and so we're out there on the road. We were literally on the road before COVID hit, but definitely out there providing the education and answering those questions. So with that, it looks like we have about 5 minutes left. Amy, are there any questions for us in the chat? Or anybody else, feel free to unmute your microphones and we'll take those.
I haven't gotten any just to me. So I think you guys can see the full chat.
How many states to date have similar law that if advanced directives overrides the POLST if a conflict? And I think that was for you, and I don't know the answer to that.
Yeah, we don't keep track of the specific number, but I know that there's at least a few because we've had multiple conversations, and it was enough that we wanted to include it in our legislative guide. So I put the link to the chat, and if you look at pages 8 and 9, that's how we've addressed it.
Okay, excellent. Thank you. And do we have the slides? And I said, yes, we're happy to share. The only way Arizona has gotten to where we are today is through National POLST and other states sharing with us. I can't tell you how many times I've been on calls with California, New York, different states, just brainstorming. Okay, what are you doing? How can we do that? And thank you, Amy, for all your support to be in Arizona becoming an endorsed state and really developing a robust infrastructure. We certainly are very thankful for the support of National POLST.
One question, Mary, I'm not sure if you don't mind unmuting to clarify a little bit further, but you said DNR if it conflicts with the POLST?
So we've not had that issue in Arizona. We do have a slide in our work that, we do have the difference between what's called the pre-hospital medical care directive and the POLST form and that type of thing, but we've not had that come up in Arizona. I do get questions, do I have to do that pre-hospital medical care directive and the POLST? And because that orange form, that pre-hospital medical directive form is sacred to EMS, they like it, but I can see them softening up. I think eventually we won't have it anymore, but to be determined. And there's a question from Charles Key from Tennessee. For states that have adopted the Uniform Healthcare Decisions Act, a patient's subsequent written expression indicating an intent to revoke their prior AD is effective as a revocation. I would argue that POLST would do that. If we understand POLST as a special kind of portable DNR, then a standard DNR ought to be still be valid. I can't answer that. I'm not familiar with that, but we look at POLST not as part of a DNR or an advanced directive. We look at it as an advanced care planning document.
And I can speak briefly to that. The Uniform Law Commission is reviewing right now the Healthcare Decisions Act and updating it, is my understanding. There's been some conversations about whether or not they're going to pull POLST into it, clarifying that POLST is not an advanced directive, but a portable medical order, and that out-of-state POLST forms should be honored. I think, Charles, part of it just depends on whether or not a state is going to interpret the POLST as an advanced directive and part of that, or separate, and there's some state laws that vary. I don't know that there's a definitive answer about how the Uniform Healthcare Decisions Act actually plays into POLST, especially when there's a conflict. I think that's just gray area there. I don't know anything further about that, but those are the conversations that I've had so far. The question from Mary, is the DNR considered an advanced directive? No, the do not resuscitate order, like POLST, is a medical order. An advanced directive is a legal document, so they aren't the same. And in an ideal world, they're considered separate documents. So it wouldn't be one controlling the other, it's that they're separate. An advanced directive speaking about wishes, and a DNR actually giving a medical order. Sandy or Vicki, I don't know if you have more to add to that.
No, it's we agree 100% with what you're saying. It's not an advanced directive in Arizona statute. It's, even though it's, it's in statute, but it is a medical order.
All right, well, we are at time. So thank you so much, Sandy and Vicki, for sharing your experience with Arizona. I think that it raised some interesting questions for those of you that are on the POLST forum. I did already put a link in there about how do you stay on top of your legislation, especially if you don't have resources. So if you have an answer to that, please go to the forum and answer the question to share with everybody. Otherwise, we will be posting this on the website. Sandy, if you want, you can send me the slides and I can send it out to the people who attended. But if you have any questions, feel free to reach out to Sandy and Vicki, whose emails are here. And of course, you can always reach out to me at amy@polst.org. But thank you very much for your time. And thank you, Sandy and Vicki, again for presenting.
Thank you.
And just a reminder, we do have one more presentation next month on national forums where we will hear again from Sandy and Vicki, along with leaders from New Hampshire and Maine. So please register for that if you haven't already.